As is usually the case, the post was advertised, both locally and internationally, and then the applications were received. And the bar's involvement normally comes at the interview process, in that we form a part of an interview panel that is appointed to interview the prospective candidates. We don't get to choose who's appointed. We only get to recommend who we think is the best choice based on the interview process.
There is this notion that perhaps the acting Chief Justice was glossed over. I understand that she never applied for the job, but perhaps in some corners people are thinking, well, she was in that acting capacity for at least a year and a half or so. Perhaps the job or the first preference should have been given to have her confirmed.
I'm not aware of any such practice. To the contrary, that has never been the case. When there's a vacancy in the office, the vacancy is advertised, and anybody who meets the qualifications can apply for consideration for appointment to the post. The acting Chief Justice was free to apply, and she, having acted and being able to demonstrate a track record in the office, may have given her advantage in the application process. But having acted doesn't mean that you automatically get appointment without having to participate in that process. I mean, that has never been the case. The last person who held the office in an acting capacity was, I believe, Mr. Justice Samuel Awich, and he served in acting capacity for a number of years. He was never appointed. He was elevated to the Court of Appeal.
Which is similar to what is being proposed in the case of Justice Arana.
Yes, it looks very much like the same thing.